I firstly refer respectfully to the case Ellis Tamaklo against the Republic. Ellis Tamaklo is an unreported decision, as far as I'm aware, of the 20th January 2011. And your lordships will forgive me if it is reported and I'm not aware of the report, but I have a copy of the
suit number, please.
The suit number is CM number J7A/1/2010. And in the ruling of the court read by Justice Atuguba at page 2, after referring to the applicant's grounds, his lordship says, in his supplementary statement of case, he identifies the issues raised for review as follows. And I refer to the passage in his supplementary statement of case. He identifies. So, my lord, the court clearly granted leave, and a supplementary statement of case was filed and relied upon and considered by the court in that case. That was a review application in the Supreme Court of Ghana. My lords, I also wish to refer your lordships to the case of Standard Bank Offshore Trust Company Limited, substituted by Dominion Corporate Trustees Limited, against the National Investment Bank Limited and others. That was an appeal to the Supreme Court from the Court of Appeal. And in that case, the appellant, that is the first defendant appellant, applied for leave to file a supplement to the statement of case. That is also a civil appeal number J4/2016, civil appeal number J4/63/2016. And in that judgment of the court read by Justice Benin, there is explicit reference made at page 2 to an application to file a supplementary statement of case, which was granted on the 6th of April 2017. and the court proceeded in its judgment to consider the matters raised in the supplementary statement of case filed pursuant to an order of the court on the 6th of January. I also wish respectfully to refer your lordships to a decision of this court Al-Hassan Amidu versus Mutiu Alawiye and 6 others, which is a decision in a civil appeal J4/54/2018. And in a decision of this court on the 24th of July 2019, reference is again made to the fact that a supplementary statement of case was filed, and that reference is actually made in the dissenting opinion of Justice Appal in that case, where under the heading Plaintiff Submission in Brief, he refers to the supplementary statement of case filed on the 27th of June. Yes, my lord.
The last 2 cases you've cited.
I'm sorry?
The last 2 cases you've cited relates to an appeal, as you said. The last 2 cases you've cited relates to an appeal. I think that's what
yes, the last 2 cases, I'm aware of that.
Not a review.
My lord, there is, with the greatest respect, in this context, there is no difference, because in respect of an appeal, the same requirements, my lord, in this connection, the same requirements as regards how an appeal is to be lodged are provided. And I respectfully wish to refer your lordship to the rules governing appeal. That is Rule 15, Sub-Rule 6, which says, in precisely the same way as is provided for in review, it says the statement of case of each party to the appeal shall set out the full case and arguments to be advanced by the party, including all relevant authorities and references to the decided cases and the statute law under which the party intends to rely. And B, in the case of a respondent, may include a contention that the decision of the court below be varied. My lords, that yes, 1511 says, notwithstanding anything to the contrary contained in these rules, any party to a civil appeal may at any time before judgment apply to the court to amend any part of the statement of his case, and the court may, having regard to the interests of justice and to a proper determination of the issue between the parties, allow the amendment on such terms as it may consider fit. Now, my lord.
Now, when you go to review, is there a similar issue as 1511?
My lord, there is no similar provision, And we are not asking, as far as the supplement is concerned, that is not an amendment. As far as paragraph 28 is concerned, yes, we are seeking to make an amendment effectively. But in respect of the supplement to the statement of case, that is distinct from an amendment, because respectfully, a supplement is meant to add some things to the statement of case. An amendment, respectfully, is meant to change something that you do or something that you've already provided the court. So there is an important distinction. And what I'm drawing, respectfully, what I'm drawing attention to in the first instance is in respect of the supplement to the statement of case. I will come to the amendment also, if your lordships will allow me. So I'm respectfully saying that not the review jurisdiction in its statement about what should be in the statement of case is no different from what is provided for in respect of appeals. And the review jurisdiction is provided for in this particular instance as far as the statement of the applicant's case is concerned. The review jurisdiction is provided for in Rule 56(1). The application for review shall be by motion supported by an affidavit and accompanied by a statement of the applicant's case, clearly setting out and fully arguing all relevant grounds on which the application relies. And my respectful submission is that that is no different from Rule 15(6)(a), referring to appeals, which says the statement of case of each party to the appeal shall set out the full case and arguments to be advanced by the party, including all relevant authorities and references to the decided cases.
Mr. Chikata?
Yes, my lord.
This way, I'm here. This way. Is there any reason why that 1511 is not repeated for this one?
My lord, I cannot say that there was a reason in the minds of the Rules of Court Committee, but as I indicated a few moments ago, I wanted to finish my submissions on the supplement to the statement of case and then address you on the amendment, if respectfully, if that is a satisfactory approach. I wanted, because my lord, my lady's question is getting back to the amendment issue, and I respectfully requested that I be allowed to complete my submission on the supplement to the statement of case, because I have a couple more authorities that I wanted to advance. So
I will wait. I will wait.
Very well. So in respect of the supplement to the statement of case, I have just referred your lordships to Amidu and Alawiye, and I proceed further to...
Chikata,
Yes.
I want to understand your argument. Your submission is that it has been the practice to allow supplements, and therefore this court should allow the supplement as a matter of practice. And you also refer, and that's it, right? As a matter of practice. Not because the rules are, not because you can see an indication in the rules, but because going through the decided cases, you see that it has been the practice. Is that your submission?
That is not my submission.
What is your submission?
My
exactly?
submission is that your lordships, in their wisdom, in interpreting and applying the rules in CI 16 have considered it an appropriate exercise of jurisdiction to grant leave for the filing of a statement of case. Your lordships have done that. And therefore there are precedents that show your lordships interpreting and applying the rules concerning review as well as the rules concerning appeal in a manner that allows for a supplement to be available to the court as part of the process of determining an appeal in one case and a review in the other case. That is my submission. And my lords, respectfully, I do not believe that the practice of the courts in terms of the precedent that I cited, I don't believe that that practice has simply been an arbitrary practice, especially when, as I show, there is a certain pattern and there is a certain consistency with which this court has enabled counsel to file a supplement where it considers it appropriate. And my lords, the next case that I want to cite, in fact, illustrates exactly this point as regards the court's considerations when an application is filed for leave to file a supplement of case. This is the case of Nora Otu and Reuben Otu, which is a civil appeal number J7/3/2015, and in that instance, a single justice refused an application to file a supplement to the statement of case. And then, when it went before the full panel, they upheld the decision of the single justice. And the reason they upheld that decision was not because the rules did not allow for a statement of case, but because the lordships held, per Justice Badegbe, that this particular application was seeking to bring a new matter that was completely unrelated to the issues in the appeal. So in that case of Nora Otu and Otu, the determination by the court was that in order to try to bring in new matter, the court would not exercise its jurisdiction to allow for leave. The court did not say that the rules do not allow leave. The court said, in respect of the new matter, we cannot grant leave. And my lord, the final case in respect of a supplement, the final case that I wish to refer to is again, your lordships, I'm sorry, there is actually one more case before I get to the final case. That is Nunu against Ataglo. Nunu against Ataglo.
Could you kindly spell Ataglo?
I'm sorry.
Kindly spell Ataglo.
Ataglo, A-T-A-G-L-O.
Thank you.
And that is civil appeal number J4/73/2018. That is a decision that your lordships rendered on the 28th of July 2020. And in that decision, Her Ladyship, Justice Doji, in reading the judgment of the court, as I think it was, a unanimous judgment, Her Ladyship again refers to a supplementary statement of case filed by the defendant upon the orders of the court that the parties address us on the legal effect of a provisional land certificate. So in that case, significantly, the court itself ordered a supplementary statement to be filed in order to address a particular legal matter. And that was exactly what happened also in the last case that I would like to cite, which is a case, consolidated rates, decided on 25th of June 2020, National Democratic Congress against Attorney General and Electoral Commission of Ghana and Mark Techi Banson. That suit, well, the first suit is numbered J1/9/2020. And the second suit, which was consolidated with it, is J1/12/2020. So National Democratic Congress versus Attorney General and Electoral Commission of Ghana and Mark Techi Banson against the Electoral Commission of Ghana and Attorney General. Now, my lords, in that case also, in the decision that was read by Justice Professor Kuti, reference is made to the fact that the court directed the second defendant to file a supplementary statement of case to provide the legal basis for the non-inclusion of the current voter identification card as a document to be used for the identification of a person who applies to be registered as a voter in the compilation of a new register of voters. Option was given to the other parties to file supplementary statements of case if they so desired. All the parties duly filed supplementary statements of case. So, my lords, what I'm respectfully submitting is that your lordships have recognized that the supplementary statement of case, or the supplement to the statement of case, as we have referred to it, where it can assist the court to address the matters that are an issue before it, may be entertained. Where the supplementary statement of case can assist the court in addressing the matters before it, it may be entertained. Now, my lords, I am obliged to refer also to a decision which I do not yet have a certified true copy of, but a decision made on Tuesday by your lordships in the case Republic versus the High Court, who ex parte Attorney General.
And so you're live here on the JoyNews channel. It is our live coverage of the 2020 election petition. We lost the audio in that particular feed. Once we correct that, we'll go back to the Supreme Court. We can now go back and hear Mr. Chachu make his case.
Citing that case in course of argument, yes, he is entitled to refer to a decided case. Even at the Supreme Court, you can refer to a Court of Appeal decision. Yes.
Very well.
Yes. It's just.
But I want to correct a wrong impression. The application was not merely to file a supplementary statement of case. The application was to file an additional ground of appeal. And it was ground of review, additional ground of review. And it was on the basis of the additional ground of review that the supplementary statement, you wanted to file a supplementary statement. So if you cannot file additional ground of review, then there is no need to file a supplementary statement of case. If the supplementary statement of case is based on the original grounds of review, it's a separate matter. There should be a distinction between just asking to file a supplementary statement of case in respect of the grounds of review that we have already filed, and then leave to file additional ground of review, and then a supplementary statement of case because of that additional ground. There are two different things.
My lords, with the greatest respect, that application, which also happened to be filed by us, that application was indeed to add grounds of review and to file a supplement, and that supplement was to address not only the additional ground of review, but that supplement was even to address a ruling of the court in respect of bias, which we had applied for and we were still waiting to receive. That supplement was to address even that. And we were not allowed on the simple basis that the rules regarding review did not provide or did not allow for such.
Mr. Chikata, if I recall, that supplement was also to allow you to fill in holes that you had left in your submissions. So if we can get back to today's business, please.
We did not, it was not meant to fill in holes, and that may be your lordship's interpretation.
The holes were numbered Q, N, and 0. I was and O. I was actually part of that panel. Thank you.
The whole, your ladyship, the grounds were numbered Q, R, S, T. I'm not sure I know what the Q, N, and O that you're referring to. The grounds were numbered Q, R, S, T were the additional grounds that we sought. My lords, I mean, the documents are there, so there's perhaps no need to try to dispute, but I don't know what the O that you're referring to is.
Omissions, you said, if you remember, you said you had applied for the order of the court and you have not received the order. And so you left some holes, some missing holes.
No, my lords,
you had applied for an order from this court and you have not received the order.
My lords, with the greatest respect, what we said was that in the draft statement of case, which we attached to our affidavit, where we had Q and R, yes, there was nothing written under Q and R. It was blank. It was blank, and we gave a reason. The reason being that we to enable us to address those grounds. Well, I mean, the rather colorful language of filling holes may not apply to what we were seeking to do, because
Mr. Chikata, I think we should have timed you.
I'm sorry.
I think we should have timed you from the beginning. We should have given you time from the beginning. Because it looks as if you are going.
My lords, I'm not. My lord, respectfully, my submission is that that decision that was delivered by this court on Tuesday, by another panel of this court on Tuesday, that decision was in clear error. And it was in error because it was not consistent with a pattern of decisions which I have referred to, in which this court has exercised its discretion to grant leave for the filing of a statement of case. And my Lord, my fundamental submission is that this court, in the exercise of its discretion in hearing a review, is able to consider an application for a supplement to the statement of case. And my lords, I am respectfully submitting that the critical consideration for this court is really as to whether that supplement to the statement of case will enable this court to administer justice. And in a matter such as in that case, where the court was being urged to allow for the statement of case, not only because even a ruling in respect of which the original statement of case had been made, that ruling had not been made available to the party, but also because, as the court, as was indicated, there were a number of unreported decisions which the court was now being furnished with. So, my lord, where the application to file a supplement is to enable the court to be furnished with additional decisions of itself, which decisions are binding according to the constitutional provisions governing the exercise of jurisdiction. My respectful submission is that this court is able to exercise a jurisdiction for that supplement to be made available. Now, my lord, in this case, as your lordships will see from the drafts that we have submitted, the draft of the review, the draft of the supplement, we actually seek to provide this court with further assistance by way of additional authorities that are made available. Now, my lords, if I may, just before concluding, if I may touch on this question of amendment and how it differs from the supplement from the statement of case, which has been raised by your lordships. Now, my lords, in respect of appeal, yes, there is a specific right provided for applying for an amendment. There is a specific right. And my lords, my respectful submission is that the distinction between that and the review situation is fairly simple. The distinction is as follows. In the case of the appeal, the appellant is given a distinct right to ask to amend. So that is a specific thing provided for in the rule. In the case of a review application, my respectful and humble submission is that it is open to the court in the exercise of its discretion in hearing the review, where it finds it appropriate in the interest of justice to allow for the supplement to the case. So that is the distinction that I wish, in answer to your ladyship's question earlier. That is the distinction that I wish to make clear. That in the case of an amendment to a case in an appeal scenario under, I believe it's 1511, in that case, it is explicit that any party may at any time before judgment may apply. So there's an explicit opportunity provided to parties at any time before judgment to apply to amend their case. Now, in the review rules, there is no such equivalent. But my respectful submission is that that is because in the context of a review, what your lordships may do is within your broad mandate in the interest of justice to consider what is brought before you. So, my lords, for instance, respectfully, for instance, if in the context of an application for review, a matter that relates to compliance with the Constitution is being sought to be raised before you, as your lordships have made clear in many cases. When a matter related to the Constitution is being brought and enforcement, or there's an issue of breach of the Constitution which needs to be addressed, like was done in the famous Balkan energy case and so on, in that case, your lordships will, of necessity, respectfully, exercise your jurisdiction to entertain it, because your lordships are here to uphold the Constitution, no less, no more. So, respectfully, that is the difference between the opportunity provided under 1511, where appeals are concerned, and the review jurisdiction. Now, yes, it is conceivable, it would have been possible for the drafters of these rules to say that they are importing the same specific rule about amendments into the review jurisdiction. It would have been possible for them to do that. But, and I do not wish to enter into the minds of the drafters of these rules of court, because they are generally a very distinguished panel of, professionals, judges, and so on. And I do not wish to pretend to know their minds, but suffice it to say that in this CI 16 as it exists, they did not provide for that specific amendment rule when it came to review. They didn't do that. And my respectful submission that one cannot imply from that, therefore, that this court, in the exercise of its review jurisdiction, is bound from entertaining an application which involves an amendment. Because, in my respectful submission, this court has the jurisdiction and it has the opportunity in exercising its authority as far as reviews are concerned to consider what is in the supplement, what is, especially when a draft has been provided, and what is in the proposed amendment, and this court is able, in the exercise of its jurisdiction, to consider the matter.
Of which is the review jurisdiction. Laws, the rules governing review are very, very strict, and parties who seek a second bite of the cherry by way of review must strictly comply with it. My lords, insofar as the application before this court and all the other applications filed by the applicant seek to undermine CI 99, which basically, my lords, deals with my lords, I am dovetailing the point that the review jurisdiction is very, very strict. Yes, and I'm saying that the nature of the review do not permit the grant of this application. That is why my learned friend has not been able to cite one single authority on the point. All the references made, my lords, are in respect of appeals, and some regarding original jurisdiction. Original jurisdiction.
I must. The first, yes.
We will give you leave to respond appropriately, yes.
Well, that's my submission. That is my submission.
Yes. My lords, we are opposed to this application. First, our submission is that this review jurisdiction of this court is a very special jurisdiction. And you are, because of its special nature, the parties are given only a month within which to bring an application. They cannot apply for leave for extension of time to bring an application for review. Unlike an appeal, where parties are given 3 months, and even after that, they may bring application for extension of time. My lords, this is because that jurisdiction seeks to have the highest court of the land review its own decision. Now, so no one comes to the Supreme Court applying to amend its review or grounds of review as of right. Where there have been cases where the Supreme Court has exercised its discretion to grant such amendment, they must be dependent, if any at all, on the specific circumstances of the case. My lords, our submission here is that the additional ground that the applicant seeks is on the face of it no ground at all. Because what the applicant is saying is that because Article 129, is it 4? 4 refers to the power of the court to exercise all other powers of lower courts. Thereby, CI 47 has been raised to a constitutional status. My lord, with the greatest respect, I think that that argument is misconceived, because if that were so, then all laws, acts of parliament, other subsidiary legislation, including CI 99, because they have their roots from the Constitution. From the Constitution, therefore also have been raised to the same constitutional status. My lord, on the face of it, this cannot be, it simply cannot be a valid ground. Let me also add, with respect, that the Constitution actually provides a rules of court committee to make rules to govern the procedures of the courts of our land, including the Supreme Court. Does that mean, therefore, that CR 99 is also raised to a constitutional status. It is for this reason that I think that the court should not exercise its discretion in granting what is a palpably misconceived application of them.
We will give you 5 minutes to reply on point of law.
My lords, if I may start by responding to the last submission made by counsel for the second respondent. And if I may make it absolutely clear that nothing in my submissions suggests that I'm elevating CI 47 or any other CI to the status of a constitutional provision. Absolutely nothing in my submission. Second, I would respectfully submit that the right of review is indeed a right that is provided for in the Constitution. And your lordships have had the opportunity to address its significance in the case of Bernard Mona.
Arise from their submissions.
My lord, it does, because
No.
yes, and my lord, yes, my lord, what I was addressing was the fact that
They're not saying you have a right to apply for it. That's not what they're saying. You have a right to refuse to apply for it. You go the reason to this way. But they're saying that. With the nature of the rules that have been carved by the Rules of Court Committee,
we're not allowed.
Of Rule 54, we cannot entertain an amendment. That is our supplement.
Right, my lord.
That's why, Mr. Chairman, that is why you began your argument, your submission by saying that you are invoking the inherent jurisdiction of the court.
That is correct.
Yes.
That is correct. So my lord, very well. My lord, I will not refer to that case. I was going to refer to part of the judgment, but for the moment, without reference to that judgment, I just wish to say in response to that matter that in our respectful submission, the additional ground that we seek to bring, which relates to Article 1294, in our respectful submission, will also enable the court to consider the extent of its powers, the extent of its discretion in order to hear the review that we brought before the court. So that article of the Constitution is an important basis for the exercise of the discretion that we're seeking to bring. That is what makes that relevant. Now, my lord, as far as as far as counsel for the first respondent submission are concerned, my only response is that counsel has entirely misunderstood the nature of the application before this court. He's misunderstood the nature of the application before this court.
My lords, with the greatest respect,
Because in the nature of the application that we have brought before this court, we are saying explicitly that this court, under its inherent jurisdiction, in the hearing of the review application, has a range of powers that it may exercise in the interest of justice. It is absolutely also not correct that we did not cite any case concerned with a review. The case, Listamaclo and the Republic, which was the first case that I cited, was precisely in the nature of a review. So it is simply false for anybody to say that the authorities we cited did not include something on review. Furthermore, we demonstrated that on this particular aspect, the exercise of the review jurisdiction cannot be any different from the provisions regarding an appeal in this particular aspect. That is all.
Please, you will rise and consider.
All right.
On the JoyNews channel, it is our live coverage of proceedings in court, the 2020 election petition, and we've been hearing the lawyers for the various parties, from the petitioner, the first and second respondent, argue on the issue of review. The lawyers for the petitioner essentially wants the leave of the court to amend a review to an initial case that was decided on by the court, which is the issue of interrogatories. And so the substantive review, even though the court has been reconstituted, and you would notice that we have now a panel of 9, the review for the supplementary application or supplementary documents to be filed for the substantive review is what has been heard. The court has gone on recess to decide on that, and then the issue of substantive review will be heard. I'm here with my colleague Mama Osabaje, who's been following the proceedings as well. A lot has happened this morning already, and to think that we have a lot of issues hanging for the court to deal with, in view of the fact that they have also they adjourned the courts to begin the hearing proper of the substantive petition today. It only remains to be seen how the justices will direct for the case to proceed.
Absolutely, Kojo. So what we've been listening to really is lead counsel for John Dramani Mahama, Mr. Chacha Chikata, make the case for the court to allow his team to file additional document to their case, seeking to review the court's interrogatories ruling. This is a decision the court made sometime on the questions, the 12 questions that the lawyers were hoping the court will allow the Electoral Commission chair answer. The court decided dismiss that case. I understand we have our correspondent Joseph Akable.
Yes, let's speak to Joseph now for some more on what has been happening in the Supreme Court. Joseph, thank you very much for joining us. Now, first of all, let's start with the panel. We noticed that it's been reconstituted. We have now 9 instead of the initial 7. Who are the other 2 justices who have joined?
And so far, Justice Professor Henrietta Mensah-Bonsu joined the panel, as well as Justice Amadou Tanko. And these are also 2 fairly new judges by way of the Supreme Court, and they were added. You recall when the case was called, Mr. Chikata had wanted to proceed to deal with these applications, and the point that the court made was to the effect that they wanted the enhanced panel, in the words of the Chief Justice, to deal with that. And so Professor Henrietta Mensah-Bonsu and Justice Amadou Tanko joined the panel, and that they make the 9-member panel for now.
And when we joined the court, the arguments for the application for additional documents for the review was being argued. Did anything happen before then that you can bring us up to speed on?
And so before then was the fact that the CPA had indicated that they were reconstituting a panel, which I alluded to. And so that was what transpired before that particular feed came live. And so that was what had happened before.
Very well. And so, Joseph, now we have heard the justices, the counsels make the argument. If you can just give us a brief of what the counsels have been saying in respect of this particular application.
And so, to take a step back to what exactly the issue is that they are dealing with now.
Very well.
Essentially, the review of the interrogatories. The question has been made that they wanted to subject the EC chairperson to some 12 questions. Now the court declines that request. The NDC has found that an enhanced panel takes a second look at that particular decision. Now the NDC, after filing, Mr. Mohammed after filing for that review, now found another document to say that, look, there's an important piece of argument or ground that I need to attach that I want to bring to the attention of the court. It's not part of what I initially gave to you, but I want to attach it to bolster my argument. And this specifically is an argument they are hinging on Article 1294 of the 1992 Constitution. Now, Article 1294 of the 1992 Constitution makes the point that the Supreme Court has the power to exercise the authority of any court. Now, the NDC's argument is that the Supreme Court, in its decline of their quest to subject the EC chairperson to the interrogatories, did indicate that it is the governing rule currently is CI 99, which amended CI 16, which calls for an expeditious hearing and also a genuine case for relevance of those questions have not been established. And so that was the basis for the court's decline. The NDC's argument is that that contravenes the Constitution because the CI 47, which is the High Court rules, which they had relied on to make this request, they say that Article 1294 entitles the Supreme Court to exercise the power of any court, including the High Court. And so they are seeking to submit this ground to attach the evidence to say that, look, you made a mistake in that you have the power to exercise the powers of a High Court and any other court for that matter. And so you should not have said that because of the CI 99, which amended CI 16, we should not be allowed, or you will not exercise the power to allow for such interrogatories which are administered at the High Court anyways. And so that is the ground that they are seeking to attach. And Mr. Chikata makes the point that there is one case which is cited, which is the case of Ellis Tamaklo versus the Republic. It was a review case where he says, reading from the judgment, it is obvious that the court allowed for such a supplement to be done. At the point that Professor Henrietta Mensah-Bonsu, the Justice of the Supreme Court, who joined the panel, was making to him was to the effect that the rules of the court that Mr. Chikata had read does not explicitly provide for such amendment in relation to reviews to be done. That is to say that if you are asking the court to take a second look at its own decision, you are not allowed to now come and make changes to the document. And he makes the point that Mr. Chikata in his response says that, look, the court has the discretion to exercise. And he is simply saying that I am making reference to a constitutional provision. Your job as a Supreme Court judge and as a Supreme Court for that matter is essentially to uphold the Constitution. And so if there is a reference to the Constitution and there is a relevant ground that will help the case and it will help a judicial determination of that matter, you should permit for that to be granted.
And essentially, he also says that this is a matter of whether or not it will help the justices in delivering justice as far as their petition is concerned. But then I had that response from Akoto Ampao, who makes the case that it is not as of right in the matter of the application they are seeking, but a matter of discretion the justices would have to exercise. Absolutely. And he, originally they are not even the persons who are dealing with this interrogatory. That is Director of the Electoral Commission Chairperson. So that's why he had to make the point that they are opposed on a point of law, because once they are parties in the case, they will only be allowed not to plead facts, but to speak to the issues on a point of law. And the point that he made was the fact that the review jurisdiction of the court is of a special nature. It's because the court, the highest court of the land, has taken a decision. And so if you are asking that they should take a second look at it, you should come prepared. And he distinguishes that from the normal appeal process. An appeal will take place when the court has, for instance, finished with the case and you are asking it to take a second look at it. He is saying that in terms of an interim issue, we are dealing with a substantive petition. You've come in that you want to administer interrogatories. He says the rules are so strict to the extent that it is to be done within a month. In fact, he says you are not even allowed to, even if you need more time in order to solve for it, you are not even allowed to even come to the court to ask for more time. And so he says that due to that special nature, this kind of request is not allowed. Then he goes a step further to attack the ground that they are seeking to attach. The Article 1294 that Mr. Chikata argued that it empowers
the Supreme Court to exercise the powers of every court. It then says that if that is the case, then it means that all other legislations that have been passed by Parliament that regulates all various courts will simply be binding on the Supreme Court, because they will simply say that, oh, whatever court it applies to, because the Constitution says the Supreme Court can exercise its power, immediately you make reference to the Supreme Court would have to apply it. And so that was the point that he was making. And Mr. Chikata, you heard in the very final stages, make the point that that is not the essence of the submission. But the essence of the submission is making is that the court has the discretion and the court should exercise it favorably because they believe that the court made an error, and this particular ground, the 129 for which they are starting, will point out that indeed such an error was committed.
And it appears the counsel for the first respondent, the Electoral Commission, is simply sticking to the rules of review, which he says does not allow for the leave that Mr. Chikata is seeking.
That is so, and he also makes the point that if you are seeking to have in his own way a second bite at the cherry, you should come prepared, and once you are seeing that just a second look, you don't come and put another request that you should be allowed to attach additional documents. And so, interesting in terms of the development so far from when proceedings started at 9:30. But the point needs to be made is that substantively, the review itself will not come to the arguments relating to the review. And so, the court has gone on recess to return and rule on the request to be allowed to allow Mr. Mohammed's legal team attach the additional ground. And if they decide to allow that or not to allow that, we'll now have to deal with the review proper. At the start of the proceedings, too, I just worth noting that there were some two outstanding applications that were withdrawn.
Right.
And so the first was the stay of proceedings. You recall Mr. Mohammed's team had said that the court should put its proceedings on hold because of this review. That was filed and was supposed to have been argued on Tuesday. But Mr. Chikata will do it because the review is settled for today. And so it was moot because you can't ask it to stay when what it actually has to deal with today is the review itself. And so that particular court of proceedings request was withdrawn. And so the court struck out that application as withdrawn. Okay. The second application that was equally withdrawn was from the camp of the Electoral Commission, that is the first respondent. That relates to a request that was saying that there should be an abridgment of time. You recall on Tuesday, this particular matter was slated for today's Thursday, and so the EC was asking that if the court was sitting on Tuesday, they should have dealt with the review on Tuesday instead of Thursday. That is equally moot because today is Thursday, and the court is dealing with that as well. So Mr. Amenubo, who represents the first respondent to the Electoral Commission, withdrew that particular application as well. And once he withdrew that, the court struck that out also as withdrawn. And so those were the two initial issues that the court dealt with immediately before it dealt with the arguments related to the additional argument.
And that is very interesting. Mamavi and I earlier spoke about that because we were of the view, and when we spoke to some lawyers who educated us on this, that the court will initially deal with the issue of stay of execution before moving on to the review proper, Mamavi.
Yeah, that will be the stay of proceedings. Exactly. So thanks, Akable, for bringing us up to speed on this one. How about the request to inspect and run copies in the custody of the Electoral Commission?
Those matters have not come up as we speak now. They remain equally outstanding. They have written to the Electoral Commission. The last time Mr. Chikata spoke about it in the report, he said that they had not obtained a response in terms of either allowing them to go ahead to carry that out or not. Again, the point was being made that they have equally not been permitted by way of the admission of facts to also go to, which is 18 facts are completely different from the other interrogatories that they are seeking to push. And so for now, we're still the review, the request to bolster the arguments, which is outstanding. And once the court comes back, the court will deal with the other aspects of the issue.
And I'm wondering, in your interaction with some lawyers ahead of this case, did they explain to you why the reconstituted panel, had the issue of the application for additional document and not the substantive review itself?
So this same panel will be the one that will deal with the substantive review itself as well, because it was the original 7 that dealt with the request relating to the interrogatories. And so this panel, in fact, when the case was called, Mr. Chikata was now proceeding to move to motion relative to the request to file an additional argument. And the court did indicate to the Chief Justice, who is the president of the panel, that the new panel, i.e. the enhanced panel, with the two justices, Justice Professor Mentabonso and Justice Amadou Tanko, joining will now come in to deal with it. And so that is the explanation that the panel itself put out there, that because it relates to the review, and it goes to the very root of the review itself, in that an additional ground is being brought upon, which could potentially be granted and could potentially affect the review and push it a certain way or not. The court took the view that the enhanced panel should come in to deal with it, and that is what is happening.
Very well. And Akable, just before you go, Mr. Chikata in his argument referred to the cases that, a particular case that went before the court before the election and cited some authority or decision from that particular case. If you can just help us understand what Mr. Chikata was trying to argue.
It was the voters register case, the case that was filed by the National Democratic Congress versus the Electoral Commission and Attorney General, as well as the Mark Banson case. If you recall, the National Democratic Congress case had to do with the exclusion of the current voters' ID card. And if you remember, at that time, the Supreme Court panel did request that all lawyers in the case should file additional documents addressing the court specifically on why they believe the current voters' ID card should be included or excluded. And so Mr. Chikata's inference from that particular decision was to point out that that precedent shows that if the court finds something that is worthy and believes that if addressed could help it administer justice, the court will permit for that to be granted. And so he made the point that it is that same understanding that he's urging on this particular panel that, look, the 129 4/4 of the Constitution, which I'm seeking to submit to you as part of the additional argument, is very crucial to the determination of this particular matter. And so allow me to add it to it. You have done in the past what you did, and on a number of occasions, when you held the view that something was important to you doing your work of administering justice, you proceeded to allow for that to be filed. And so grant my request and allow for that to be filed. And so that was the argument related to the voters register case.
Joseph, thank you very much for bringing us all those details, and you continue to monitor the process. We don't know how long this recess will take,